All right, this is case number, email report.
Good morning. The 36th District Court of the State of Michigan is now in session with the Honorable Judge Coleman. Our court is in session. There will be no eating, sleeping, talking, gum chewing, or reading any materials. Thank you.
All right, this is case number 24-161-439. This is Capital One versus Ebony Huddleston. The matter is before the court. On filing of a motion for summary disposition, the court also has this established as a pretrial date. The motion in this matter.
IFATSIPIQUI versus Have. Sorry, Your Honor.
Your appearance for Capital One, please.
Good morning, Your Honor. Andrew Cates, P78292 for Capital One this morning.
Thank you, Mr. Cates. Good morning to you. I'm looking for Ebony Huddleston.
I'm here. Good morning.
All right. Good morning to you, Ms. Huddleston. All right. So I see the motion for summary disposition that was filed on April 22nd, and of course I have this set up as a pretrial date as well. Counsel, hold on one second. I'm looking at something. All right, so let me ask Ms. Huddleston, you did receive a copy of the motion for summary disposition. Is that correct, ma'am?
Yes.
I don't see where you filed a written response to that. I know it was just in April. You didn't file anything, any written response to that motion. Is that correct, ma'am?
No. I spoke with, I think we came to a agreement yesterday, but I just was a little late, so they weren't able to file it with the court yet.
All right, hold on one second. Let's go to the attorney. Let's see what's going on. Counsel?
Yes, Your Honor. We do actually have I do have a copy of a executed consent judgment signed by Ms. Huddleston. We reached this agreement yesterday afternoon. The amount being paid for in this case was $4,640.83, and that's inclusive of court costs of $236.12. The defendant has agreed that she will pay $150 before May 30th, and then monthly installments of $75 beginning on or before June 5th of 2025, and then the 5th every day thereafter, every month thereafter until this is paid.
All right, Ms. Huddleston, you heard the nature of the agreement that a consent judgment will enter for the total amount of $4,640.83. The agreement is that you will pay $150 of that amount by the 30th of May, and then you will begin making $75 a month payments. The first payment being due on June the 5th, and each month thereafter. Is that your agreement in this matter, Ms. Huddleston?
No, I just want to clarify, it's 75 twice a month, correct?
Oh, okay. Mr. Cates, that's your understanding as well, that it's bi-monthly, so $150 a month, correct? Ms. Huddleston?
Correct.
All right, so I will sign an order consistent with the same. Ms. Huddleston, I think indicates that is the agreement. The council, there are any adjustments that need to be made. She wants to pay this at $150 a month, $75 payment on the 5th of June, and then every other week thereafter. And
I was advised that I could settle for a lump sum at any point as well.
Yeah, that's always that
Okay.
May not be an issue if you come forward with a lump sum. Then you would discuss that and go forward with trying to reach a resolution based on a lump sum.
Okay.
Counsel, everything is square with you, sir?
Yes, Your Honor. We'll be submitting that order shortly.
All right. So ordered. The matter is resolved, and I will sign the order when I receive it. Thank you to both of you. Good day to you.
Thank you.
Thank you, Your Honor.
Bye-bye.
This is case number 25-142-801. This is Comprehensive Psychoneurological Services versus City of Detroit. The matter is before the court. I have it set on for a status conference first hearing regarding this matter. Your appearance for the plaintiff, please.
Anthony Bordelais, P748664 for plaintiff.
Thank you, Mr. Bordelais, and good morning to you. I'm also looking in this file before I come to the city. Looks like mutual, Farm Bureau Mutual Insurance and Farm Bureau General Insurance as defendants. For the city of Detroit, your appearance at this time.
Good morning, Your Honor. Ben Patterson on behalf of defendant, City of Detroit, P85118.
Thank you, Mr. Patterson. Good morning to you. Any other counsel for any other defendants in this matter? If you're here, your appearance, please.
There should be.
Counsel. Go ahead. Go ahead, sir. I'm listening to you.
There should be one more attorney appearing on behalf of the farm bureaus today. I don't know why they're not on Zoom right now.
All right. Okay, well, let's go forward. Perhaps, I guess my thinking here is that this probably is a scenario in which the parties are asking the court to set this on schedule and then bring it back for a pretrial date. That makes sense to you, Mr. Bordelais?
Yes, exactly.
Mr. Patterson?
Yes, Your Honor.
All right, so what I'm going to do is I'm going to go ahead and set it over for 60 days. And so the return date on this matter is going to be the 21st of July, July 21st, and that's going to be at 9:30 a.m. You will receive a scheduling order for that particular date. Contained in the order will also open discovery formally, and discovery will be open through the 21st of July. Any other matters the court will visit them at that time, on the 21st of July at 9:30. Any other issues that?
I have no other issues to present, Your Honor. I don't know if Mr. Patterson does.
Oh, no, Your Honor. Thank you.
All right, good day to both of you, gentlemen.
Thank you, Your Honor.
All right, this is case number 06-157-012. This is Elite Recovery Services versus LB Means. The matter is before the court on the filing of objections to a writ of garnishment filed with Michigan Department of Treasury. The record should reflect that a judgment was entered by default in this matter on the 12th of February 2007. The record should further reflect that judgment was renewed subsequent to that time in 2016, on December the 7th, 2016. And the plaintiff has brought this action, the garnishment, to collect on a balance on that judgment. Your appearance for Elite Recovery Services.
Good morning, Your Honor. Hannah McNeese, P82477 on behalf of the plaintiff.
All right, thank you, counsel. Good morning to you. I'm looking now for LB Means. If you're on the Zoom, please say last name Means, a person address on South Kane Street in Detroit. If you are on the Zoom, please say something at this time.
That's Mr. This is Blaine Smith. He's on mute.
Who's that?
Where it says Blaine Smith, that's him.
If I'm dealing with LB Means, whoever that is on this matter, please say something at this time. If you are on mute, all you need to do is hit *6 on your device and it will unmute you.
Good morning, Your Honor.
Good morning to you, sir. What's your name?
My name is Means.
All right, thank you, Mr. Means, and good morning to you, sir. All right, so I saw that you brought your objections to writ of garnishment. You said I did not receive the writ. Well, you wouldn't receive the writ. It would go to the Department of Treasury. So tell me about what your objection is regarding this matter.
I have never lived at this address.
So are you saying the address on South, live at that address, or are you saying there was another address you didn't live at?
It's another address.
Okay. All right. Wow. Madam Counsel, your response, if you will. I don't see really an objection here, but talk to me.
Sure, Judge. Yeah, agreed. I don't really see an objection. Loosely, it sounds like he might be objecting to the underlying judgment, which is not a valid objection to a garnishment. As you indicated, this was a valid judgment entered back in 2007, renewed in 16, and this garnishment was issued pursuant to that valid judgment. So again, I don't believe his objections are valid. Should there be one that he's indicating, and we would request that this objection be denied and the writ be allowed to continue and any funds being held be released to the plaintiff.
Yeah, Mr. Means, you would have to, if you believe that the judgment should have never been entered, you can raise that issue, but you have to file a different type of motion. You can't raise that in a post-judgment hearing. This judgment has been in place since 2006, and it was renewed in 2016. So the only kind of objections that you regarding the garnishment would be things like you already paid it, or that you filed bankruptcy, or the funds are exempt, or something like that. You can't raise issues like I didn't get served, or I don't know where this is coming from, or any of that. You can't raise that in the garnishment hearing. That's the underlying case. If you want to challenge the underlying case, I mean, it's been a long, long time. If you wanted to challenge that, you could still file some type of motion to try to get that case set aside. But until you do that, and unless that is granted, the garnishment is proper. You've not stated a valid objection to this garnishment at this time. So what I'm going to do, where there's no valid objection, I'd have to conclude that the plaintiff does have the right to the funds. Any funds released to the plaintiff they may be retained, and the written will continue as it relates to the Michigan Department of Treasury. I do wish both sides well. You receive a copy of my order in the mail in the next few days. Good day to you.
Thank you, Judge.
Thank you.
Your Honor, I do have one more. It's credit acceptance versus Tyler.
What's the last four digits, if you will?
One moment. Okay, the last four on this one is 0289.
Thank you, counsel. This is case number 24150289. This is Credit Acceptance Corporation versus Angel Tyler. Now, the matter is before the court on the filing of objections to a writ of garnishment. The record would reflect that a judgment was entered in this matter on the 25th of October 2024. The judgment amount is $7,268. And looking at the objection, notified of the court date, and they sold the car. All right, your appearance for credit acceptance, please.
Good morning again, Your Honor. Hannah McNeese, P82477 on behalf of the plaintiff.
All right, thank you, counsel. I'm looking for Angel Tyler. If you on this Zoom, say something at this time.
I'm here.
All right, thank you, Ms. Tyler, and good morning to you. When I looked at your objections here, you indicate that you didn't receive a court date and the vehicle was sold. Ma'am, those are defenses that you would raise in the context of underlying case. I do note in the underlying case that would not serve personal motion and a petition for alternate service, and alternate service was granted, and that service was allowed at a Drexel address by attacking, and that is valid service. So that would be sufficient notification regarding this matter. But you can't even raise that in the context of a post-judgment hearing. The post-judgment hearing deals with the garnishment only. It doesn't deal with the underlying case. There is a judgment, and because there's a judgment, that judgment gives the plaintiff the right to use that judgment to collect in a number of different ways, so if you feel that the judgment was not properly entered, you do have the right to file a motion to try and get that set aside. And I do know that this is not like one of my previous cases that many years ago. This has been just a few months ago. But the judgment was entered by default when there was not a response to the complaint. Go ahead and tell me if there's anything else you wanted to tell me regarding this, Ms. Tyler. I'm listening to you, ma'am.
I was paying my car note every month. I never missed a payment. I paid it on time. The car was originally $7,000. I ended up giving them like $10,000, and I couldn't afford it. So I told them they can come and get the car. So I was assuming they came and got the car and resold it. So to pay, I think it's $7,000. They're saying that I owe them.
Yeah, and first of all, those issues are not issues we're raising this hearing, but obviously the biggest challenge that we have here is, of course, in 2020, you financed it, and with the finance and et cetera, the charges ended up being some $20,516, and yet 22.99% interest on this. That's the problem. When they got the car back, apparently they sold it, and this, what they're suing you for is the deficiency value. But none of those issues are before me today. But again, if you believe that something is amiss with that, you can certainly file a motion in that regard. But you got a judgment against you. Once you have a judgment, the plaintiff has the right to go after your stuff because of the judgment. Let me hear from Ms. McNeese and other questions from you. Ms. McNeese.
Thank you, Your Honor. You pretty much covered it. It sounds like Ms. Tyler is attacking the underlying judgment, which is not a valid objection to a garnishment. This complaint was filed. There was no responsive pleading filed, which allowed us to obtain the default judgment, and this garnishment was issued pursuant to that valid default judgment. Again, the objections are not valid, and so we would request that the objections be denied at this time and any funds being held be released to the plaintiff.
So let me ask you, has the plaintiff received any funds at this point?
It does not look like it, Your Honor. The disclosure that we received based on this wage garnishment does not indicate that anything, it doesn't indicate a dollar amount. So I will say that nothing has processed in our office yet, and I don't see, based on the disclosure, if there is an amount being held.
Thank you, Counsel. Ms. Tyler, has money been taken out of your check yet?
$408 is being taken out of every check.
Yeah, that's the question. Let me stop you. Yeah, that's what I want to get at right now. Okay, so when do you get paid? Every week or every?
Every other week.
Okay, so right now you're being garnished at about $800 or so a month, is what you're saying.
Correct.
So ma'am, I know that the $800 is got to be a significant impact on your livelihood. Let me ask you, how much can you pay on this a month?
$150. Because my rent, I got rent. I have another car note I have to pay on that, $600.
All right, ma'am.
Okay.
All right. So what I'm going to do is I will find that the objections are invalid because they simply are. Any funds withheld, they will be released to the plaintiff. Ma'am, what I'm going to do, I am going to adjust the garnishment on this. I mean, it's $816 a month. So what I'm going to do, I'm going to set it at $125 per pay. And the garnishment will continue, but the max they can take is $125 per pay period. You still can file your motion to try and attack it that way. But taking 408, they'll be taking $125 per pay period. So it'll be $250 a month. I think that that's a reasonable amount under all the circumstances where your judgment is in excess of $7,000. But that's what the court's going to do. I continue the garnishment, but I'm reducing the amount up to 125 per pay period. I do wish you well. Good day to both sides.
Thank you, Judge. Have a great day.
Thank you. I don't know.
All right, thank you. You all set, Ms. Tyler, you'll get the paperwork in the mail for me in the next couple of days. All right, this is case number 12-12-1116. This is DLG Associates Incorporated versus Travion Greer and California Department of State Hospital. The matter is before the court on the filing of objection to a writ of garnishment. The garnishee is California Department of State. All right, your appearance for DLG.
Good morning, Your Honor. Denise Baker, P53670 for the plaintiff.
Thank you, Baker. Good morning to you, ma'am. I'm looking now for Travion Greer. If you're on the Zoom, please say something at this time. Last name Greer, G-R-I-E-R. If you're on the Zoom, please say something at this time. All right, counsel, have you had any occasion to speak with defendant Greer or any contact other than the notice regarding this case?
No, Your Honor. The objection to garnishment attempts to attack the underlying judgment, which is not valid on the court rules and is prima facie invalid. And just to briefly address those statements, the prior attorney who had handled this matter had over 13 communications with the consumer beginning in 2012. So this consumer is well aware of this action. We'd ask that the objections to garnishment be denied.
All right, thank you, counsel. I don't see where Greer has appeared, and I did look at the objections that were raised. To quote from the document, I never held an account with Aaron Incorporated. I was never properly served, notified of the court, properly defend myself against these allegations, nor do I have a document account. All of those really are attacking the underlying case, and that simply would not be something, as counsel has already indicated, that would be allowed in this hearing. Court rules prevent the same. But again, significantly, defendant has not appeared for the hearing on these objections. Accordingly, the objections will be denied. Any funds withheld will be released to the plaintiff, and withhold may continue to report it. Thank you, counsel.
Thank you, Your Honor. Have a good day.
All right, this is case number 21-172-814. This is Advantage One Credit Union versus Christopher Jackson. The matter is before the court on the filing of objections to a writ of garnishment The record should reflect that a judgment was entered in this case by default on 6/29/22 for $7,403.22. All right, your appearance for Advantage One, please.
Good morning, Your Honor. Andrew Cates, P78292 for Advantage One.
All right, thank you, Mr. Cates, and good morning again to you, sir. I'm looking now for Christopher Jackson. Christopher Jackson, if you're on this Zoom, please say something. It looks like he is not connected to the audio.
Hello?
Mr. Jackson?
Hello?
Yes,
Yes.
good morning to you.
Good morning to you, Your Honor.
I see that you filed objections to the garnishment on that judgment. You said the funds are exempt or protected by law. What do you mean when you say that, sir?
What you said, Your Honor? I didn't understand what you were saying.
I didn't understand what you said. So you said your funds are exempt. Why are they exempt? Tell me about that.
What you mean? I understand anything.
He's saying, why was the funds taken from your garnishment? Why?
Oh, I don't know why.
Who are you, ma'am?
I'm his girlfriend, his fiance.
Oh, so, okay, so your name, girlfriend, fiance? No, you gotta tell me your name. What's your name?
You say what, sir?
I said, what's your name? You gotta tell me your name, okay? Because you can't talk on my record and I don't have your name.
Doretha Carter. Doretha Carter. He kind of hard of hearing. That's why I was, and he don't, you know.
Okay, thank you. Thank you, Ms. Carter. Ms. Carter, you still there? Like we lost connection there. They're back. All right, Ms. Carter, are you back? Mr. Jackson? They're obviously having some connection problems. The same that the objection says that the funds are exempt. It sounds like the defendant is, the petitioner is now saying that he don't know why his funds are being taken, and that would be because there's a judgment against him. Let me see if I can. Mr. Jackson, are you back? Ms. Carter, are you there? All right, Mr. Jackson, are you able to hear me? Ms. Carter? They're going in and out. Counsel, are you representing Community Choice?
Yes, Your Honor.
Now, let me go on to that one. I'll come back to the Jackson matter. I know that you're having a connection problem. All right, this is case number 23-161650. This is Community Choice Credit Union versus Kaya Lloyd. The matter is before the court on the filing of objections to a writ of garnishment. And this is regarding a writ of garnishment for Fifth Third Bank as well as Henry Ford Health System. Record should reflect that a judgment was entered in this matter. That judgment was entered by, looks like by default, and the one moment here.
Hello?
summary disposition, I can indicate the entry date.
How long?
is August 2nd, 2024. Mr. Jackson, I'll be right back with you, sir. Just hang on right there,
All right,
sir.
thank you.
Yeah, I'm glad you were able to get through. Hold on, I'll be right back to you. All right, regarding community choice versus Lloyd, the judgment was entered on summary disposition on the 22nd of August of 2024 for $10,838.06. The garnishments are attempts to collect on that judgment. All right, counsel, your appearance in this regard, sir.
Thank you, Your Honor. Andrew Cates, P78292 for community choice.
All right, thank you. I have Kaya Lloyd on this zone.
Yeah.
Looks like all right, thank you, Ms. Lloyd. Good morning to you, Ms. Lloyd.
Good morning.
So you checked off the box, you said the maximum permitted by law is being taken, and then you said there is no notification of service. You said that on the garnishment regarding Fifth Third Bank. Then on the garnishment regarding Henry Ford Health System, you indicated the funds are exempt. Tell me what you're talking about in terms of your.
So what by the reason why I filed an objection is because community choice, they are already garnishing my check. So my money, when I get paid bi-weekly, it goes into my bank account. So they filed on April 24th to take money out of my bank account, and they put a freeze and a hold on my bank account. My income checks from Henry Ford that are already being garnished goes into my bank account. So basically they garnishing my check twice, and they took my whole entire check that I got paid, which left me with no income at all.
All right, ma'am.
And
so go ahead, I'm listening, ma'am.
And that's why I filed that the maximum is already being taken, because you can only take so much from income from someone through it.
Yeah, you're breaking up. I can't. Your audio is going in and out. I have the gist of your argument, your statements that you made. Are you able to hear me? Okay.
Yes, I can hear you fine.
Yeah, you got two separate types. You have two different types of garnishment. You're correct that as it relates to the wage garnishment, that only up to 25% is taken wage garnishment. As it relates to the bank account, any funds that are within that bank account can be garnished. So it's two types of garnishments. One is a periodic, another is a non-periodic. And so what you got hit with is you got hit with two different types of garnishments. And that's why you're experiencing the problem that you have, because they've gone after money with two different types of garnishment. They can't garnish your wage for more than 25%. So ma'am, let me ask you, excuse me, go ahead.
I was going to say, when my check is direct deposited into my bank account, it is garnishing it twice.
Let me stop.
Let
me stop. Okay, I want you to understand. That's the only reason I interrupted you. Okay, let me stop you. Once you put money into the bank account, that's not wages for purposes of garnishment. That's a bank account. So that's the problem that you're running into. And so I want you to understand that the law allows for two different types of garnishments. And because it allows for a non-periodic garnishment, that's like a bank garnishment or income tax garnishment. And it also allows for the wage garnishment. The wage garnishment is the one that has limitations on it. And so if you put money into that bank account that's garnished, and even if it comes with your wages, whatever, if it comes into that account, then it's subject to a non-periodic garnishment. So that's the issue that you have. And I think that perhaps there may be some ways of resolving some of this today, but that's the nature of this situation, given the fact that you have the judgment that you have against you. Let me hear from the other side. I'll come right back to you, Ms. Lloyd. Go ahead, Mr. Cates.
Your Honor, you're 100% accurate in your statement of the law. And basically, plaintiff's position is that the wages are not exempt. There's been no proof that they're exempt under the law. The bank garnishment was properly issued, so we'd ask that both of these objections be denied this morning.
All right. So, ma'am, how much is garnished from your wages directly? What does 25% represent?
So,
Yes.
so they garnished me 3 times. What I don't have the exact numbers, but what I can say is the last time they took about 1,100, so 1,100. The second time they took about $700. And the first time they took about $700.
All right.
And
So you're
with them,
no, you already told me about the account. We'll get to that. Okay. Yeah. Here's what I want you to know. I'll let you talk, but you don't have to tell me anything again that you already told me. Okay. I got it. I got that they're garnishing your wages and then that you're automatically directly deposited into your bank account and then your bank accounts get garnished. That's what you're telling me. And the law unfortunately allows for those type of garnishments, although I think that there are some things that can be done because of the end result is that you end up paying a whole lot more out than you could afford and so on and so forth. So let's deal with this. So basically your wage garnishment comes to somewhere between $700 and $1,100 per pay period, correct?
Yes.
So you get paid twice a month?
Yeah.
So somewhere between 14 and 1,600 a month. So here's what I'm going to do. I've got to, as it relates to the bank account garnishment, I would have to find that and let me ask you, how much money is held or was released from the bank account?
So they took $611, and then there was a $80 garnishment fee. So now I'm overdraft because I don't have any money in my bank account to pay my bank for the fee that they had to pay Community Choice.
All right, got it now. All right, so I will find that the objections to the writ of garnishment regarding the bank account, those objections are invalid for the reasons I indicated on this record. The funds withheld would be released to the plaintiff. I will suspend the garnishment, the bank account garnishment further under the circumstances. So that garnishment will be suspended. Just one moment. All right, as it relates to the wage garnishment, obviously you do pretty well as the lot is being taken. The judgment in this matter started out at some $10,000. It looks like that was recently, and so you paid money, so it's less than that amount. Mr. Cates, do you have a balance at this time regarding the judgment? Just one moment, man.
I'm looking, Your Honor. I'm trying to see if they gave me a updated balance sheet. That appears to be the initial. Here we go.
And man, while he's looking, again, you got a heavy garnishment, about $1,600. How much would you like to pay on this to try and get this taken care of? If I was to give you some adjustment, what would you be thinking?
I can pay about $500 of my check biweekly.
You think you could pay $1,000 a month?
Yes.
Really? Okay.
Yeah.
All right. You wanna, I guess you kind of want to get it over with, right?
I do. That's why I'm not objecting to the wage garnishment. I'm just objecting. I don't want to be left with nothing I can't pay any. I have a disabled child. And so now I have $0 in overdraft fees in my bank account because my money gets direct deposited. So now I can't pay anything at all with the garnishment. I'm not objecting to it. I don't mind paying it. I don't mind it coming directly out just to get it over with. But I just don't want to be left with $0 at all.
Yeah, all right, ma'am, you, you had to tell me that over again. You know, I heard you on that the first time, you know, about that overdraft fee and all that. You're very articulate, but you like to tell me that about 3 or 4 times. I heard it the first time. All right, and here's, that's not a problem. I'm just messing with you, Zoe. Counsel, I am, given all of the circumstances and the amount of the judgment and what have you, I am thinking to set that garnishment at $500 per pay period. It'll be $1,000 a month. And that'll give her, you know, 7, 8, 9 months, whatever it is left, and then she'll be done with this.
No objection, Your Honor.
Yeah, I think it's a reasonable way of doing it. So that's what I'm going to do, ma'am. I've suspended the bank account garnishment. You'll have to reset things here. But again, the $1,000 a month is a reasonable way of paying it. So I will continue the withholding, but it will be up to $500 per pay. So the max they can take per pay is $500, and it looks like you'll be able to get this done in a reasonable period of time. I do wish you well on both sides, and all the best to you, ma'am. Good day to you.
Thank you.
Thank you. Good luck to you, ma'am.
Thank you. You too.
Recording.
One moment.
Hello.
Just one moment, please. I know you heard me tell you, hold on a second. You still want to, hello, 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 hello. All right, we're back on the record with Mr. Jackson. All right, and Ms. Carter was there helping you out with this. You said you didn't know why he was taking your money. And that's because you got a judgment against you from 2022. That judgment amount is $7,403.32. That's why they're taking your money. Talk to me. What else you want to tell me about that?
Tell him.
Gone again.
I don't know why it's quite quick.
All right, are you back, Mr. Jackson? Ms. Carter?
I think a very plain reading section 13.
Mr. Jackson?
Yeah, hello.
Yeah, it seems like your device keeps going out. So what else did you want to tell me about this? Because they got a judgment against you. That's why they're taking your income tax return. Talk to me.
I don't understand what the situation is, but why they're taking my income tax. What adjustment against me? I don't understand what adjustment against me for.
So I gave the car back. I paid them $5,000.
I have, my sister died. I took the car back. I paid the last payment and everything, and that's the only thing I don't know what the situation is.
Yeah, this is about a car that was purchased, and
right. I turned around. I paid the last payment. Put a payment on. I had it on it for 5 months. When my sister died, my sister was dying, and I turned around and told her it would be best for me to turn around and take the car back. And I took the car back to them and everything and paid the last payment on the car.
Yeah, but you co-signed for it, didn't you?
Yes, I did.
Yeah, that's what the problem is. You co-signed for it. Even if you turn the car back in, that still doesn't.
I turned the car back in. All right, I paid the last payment. I paid the last payment on the car. No, I put $5,000 down on the car. I only had it for 5 months. And my sister was gone. All right, and I turned around, took the car, paid the last payment on it. I missed no payment. I have with 5 months with my sister. I took the car and I had it for 5 months. I took the car back, paid the last payment on the payment when I took the car back.
Okay, now I heard you the first time you told me that, and I heard you the second and third time, okay? I want you to understand, and you disappeared. So, Mr. Jackson, the problem here is that even if you take the car back, it doesn't matter. You signed an agreement. You signed an agreement to pay $46,000 for this. And when you took it back, are you listening to me? Are you listening? When you took the car back, they sold it and there was a deficiency balance. There was some amount left over. And under the law, you're responsible for the amount that was left over. That's why they have a judgment.
How are they going to have a judgment on me at the time? I haven't missed no payment on the car. But I couldn't sit down and afford the car down with my sister. Me and my sister were paying together. When my sister died, but mom get ready to die. All right. I couldn't make the payment. I had to sit down there, call in, told them I'm bringing the car. I'd take.
All right, so, council, they keep, now, I don't think that there is a valid objection here, and if there is a concern, it will go to the underlying judgment in this matter. The circumstances here seem to be a situation where Mr. Jackson co-signed for his sister. His sister later passed away, and he turned in the vehicle because he could not or did not want to continue making the payments. But he did not get any kind of release, a document releasing him from the continuing obligation. The vehicle appears to have been sold. There is efficiency balance, as the court has articulated here. So I don't see a valid objection. This started out with the defendant saying his funds are protected. He didn't tell me anything about that. He's saying that the judgment shouldn't be a judgment against him. He has to file a motion to try to get that judgment set aside if that's what he wants to do. He can't get that motion. He can't get the judgment set aside in a hearing on garnishment. So, Mr. Cates, anything at this time, sir?
No, Your Honor. I think you've articulated exactly what my position is.
All right. So, Mr. Jackson, if you believe that judgment should not have been entered against you, you have the right to file a motion to try to get it set aside. But right now, that judgment is entered against you. As long as that judgment is in place, the plaintiff has the right to use that judgment to go after your assets to try and collect on that judgment. So I don't see a valid garnishment. You're going to file a motion. You want to do that as soon as you can to try and get it set aside if you believe that there is a reason to set that judgment aside. Again, that judgment was just entered. I think the date again, that judgment was entered on the 29th of June of 2022. It's been a couple of years, but still, if you believe that there was something wrong about that judgment being entered, you need to file a motion. The objection.
All right, the judge. Can I find a judgment for that? Can I get an attorney?
Yeah, you can do that if you want to. That's good. Or you'll get some paperwork from in the mail, sir. I do wish you well. Good day to you, Mr. Jackson. Thank you, counsel.
I mean,
Thank you, Your Honor. Have a great day.
All right. Bye-bye. Yeah. Someone was attempting to have a good idea. Fuck them up. I'm trying to jam them.
$46,000. That's a lot of money for a senior citizen. You gave the car back. I understand how they could charge you for a car and your sister died and they gonna charge you for it and you gave the car back. Plus gave her $5,000.